Greetings, I'm Wes Coulson from Dent-Coulson Elder Law, and this will be your Elder Law Minute. We're happy to present these because we think we can help inform you as to the ways in which we can help you and the things that you need to think about relative to the elder care and estate planning journey. Hope you enjoy. It's not unusual for people to leave an inheritance for minor children. Sometimes they want to do that directly, but just as often it can happen because they have a provision that says that, for instance, if one of my children dies before me or at the same time, then that one's share goes down to the family tree to their children, often being minor children. So what happens if you leave an inheritance for a minor child? Well, the answer is that it very much depends on how that's done and what document is used. If you don't have a will, or if you have a will that doesn't speak specifically to that situation, unfortunately, what's going to happen is that since minor children can't legally hold their own money or property, there's going to have to be a court guardianship set up for them in order to receive that money. So a big waste of time and ongoing expense, not only to set it up, but to maintain that guardianship until they reach age 18. If you have a will, then you can include a provision by which you would say that any inheritance for a minor child will go to them through an adult custodian through a law called the Uniform Transfers to Minors Act. That money would then be turned over to the minor child to the extent it hasn't been spent for them at an age somewhere at a minimum of 18 or at a maximum of 21. If you provide for a minor child through a living trust, you have far and away the most flexibility. You can give instructions to the trustee as to how and when you want that money to be used. You can name as the age or ages at which control over that money would be turned over to the minor child, whatever age or ages that you think are appropriate. So if you think that a young person is in general not old or wise enough to manage their money until they're, say, age 22 or 25 or even 30, you have the ability to do that in a living trust. So again, so many reasons that we tell people that living trusts are, for most people, the best way to plan their estate. Thanks.